So if you're here today, that's because you're here because you're aware that many of our students and their families are facing an increasingly uncertain future in terms of legal status, legal rights, and protections, particularly true for many international immigrant and trans students. So, as UW Bothell faculty and student supporting staff, you are often on the front lines for students who are seeking advice and support, and so that's why we are hosting this presentation today to help you equip you to understand the legal and political landscape and direct students to timely support. We are the Equity Across the Curriculum Initiative, and we are really excited to introduce you to our panelists. First off, we are going to ask questions of Judge Anthony Gipe. Judge Anthony Gipe has served as a judge for Kent Municipal Court with over 20 years of legal experience, and he's continuing to offer training on international and family law. And before his legal career, he worked as an intelligence analyst and interpreter for the United States Navy. Gipe has held leadership roles in the Washington State Bar Association, including serving as president from 2013 to 2016. He's also a founding board member of Q Law and the Washington State Bar Association's Leadership Institute. In addition to his legal work, he serves on several judicial committees and holds degrees in linguistics, Russian, and art. And in his free time, Judge Gipe enjoys fitness and painting, including the painting that is in his background behind him. Ms. Diana Muller is a Seattle civil rights and immigration attorney whose mission is to bring families together, help people gain stability and security of legal status in the United States, and work towards social justice. She represents families in issues regarding asylum, crime victim, domestic violence, human trafficking, and citizenship naturalization and immigration. Terry Kinjo is the executive director of the International Family Justices Coalition. Mr. Kinjo is originally from Japan, has over 20 years of experience in the transaction technology field, and as IFCJ's executive director, Kinjo leverages his multicultural background to provide legal support for immigrants, families in Washington, ensuring access to justice to people in need. And then Ms. Hiroko Nagano is a trauma-informed mental health counselor specializing in supporting survivors of domestic violence and their families. She's originally from Japan and studied sociology in New York, researching discrimination against women and minorities. After a 15-year career as a journalist, she was deeply affected by the 2011 East Japan earthquake and moved to Seattle to study counseling psychology. With over 9 years of experience, Hiroko has worked with organizations like LifeWire and ELAP advocating for trauma survivors. Drawing from her personal experience with domestic violence and divorce, she is passionate about supporting immigrant families in court. Hiroko also organizing parenting workshops and enjoys participating in local choirs and a ukulele group. So welcome, everyone. Thank you so much for participating in today's chat. We're going to start with Judge Anthony Gipe. Welcome, Anthony.
Good morning, everyone.
Good morning. And thank you all for the wonderful questions that you submitted for this talk. I wanted to start with your background as an artist and art of social justice. We talked about in my class, so many of my students are aware of your diversity painting. We wanted to talk about your background with the Q Law Foundation and tell us about just your intersections of art and social justice.
Okay. Well, I'm not a founder of Q Law Foundation. I'm a founder of the Q Law Association, which is the other entity. The Q Law Foundation is the 501c3 advocacy entity, but they support one another. But I contributed the diversity paintings image. They have the sole right to sell it for fundraising purposes. And I've been a supporter of the Q Law Foundation since it was started. I think if some of these are your same students as I saw when I guest lectured at your class last fall, art and social justice has been a big theme in my life for most of my life, and getting to be able to fuse them is an important part of it. So you want to narrow it down for me a bit? Because I could talk about just about anything with that lead up there, Laura.
Well, let's talk about what does diversity, equity, and inclusion mean to you as a judge. Let's
Um,
why is it important to have people
yeah.
with diverse backgrounds on the bench?
Mhm. Mhm. Yeah. There's a concept in legal judicial thinking right now about procedural fairness, right? And at being the leading concept that should be guiding judges in the administration of justice. Procedural fairness tells us it's not enough just to be applying the law. You also have to be seen to be fair in applying the law, right? And where the process is sometimes opaque to people and can't be not readily understandable, it can create the perception of injustice, even though the law itself may not be. Or it could accentuate and increase the perception of injustice for a legal uh, set of doctrines that might have some structural equity problems in them, right? So procedural fairness tells us that people coming into your courtroom have to see that the process is fair and they're treated fair and treated as human beings. Okay. DEI is very important in this regard. Because if the public coming into your courthouse doesn't feel like the legal system is embracing their community, they're not going to be satisfied with the results. All right. So I've been a big believer in most of my legal career that increasing visibility of underrepresented minorities in the profession and on the bench is an important aspect of that. That's why I helped found the Leadership Institute in Washington for minority lawyers and LGBTQ lawyers, as well as improving things like being on the task force with Q Law, on the bench guide for LGBTQ issues and for how to respond to trans-related issues in the courtroom. So things like that to help that process. So it's a very important factor because if people don't see themselves reflected in the legal system and the people in charge of the legal system, how are they going to trust it?
I do know that there was a recent change that states that judges like yourself who sit on the
Mhm.
bench are it's now a grounds for discipline if you do not refer to trans individuals by their correct pronouns.
Correct. Yeah.
And but we're worried just as educators,
Mhm.
what risks do trans students face if Washington is not their home state? For example, shield laws offer certain kinds of protection, but what will be any impact to any threats to their safety and rights should they adopt some of UW's trans-friendly practices? For example, name changes
Mhm.
on our on our Zoom. If you if you have pronouns that are she, her, they, them, and
Mhm.
suppose your classmate takes a screenshot or somebody finds out and outs them, and we're on a broader scope, what we have or we're likely to see more federal and state policies that further criminalizes their existence. How do we respond and support as educators when if and when laws become more repressive? And how do we create a culture of resistance or of not obeying in advance? I know
Well,
that's a lot of questions in one.
so there's a lot of meat in there, and in some of these areas, I think Miss Moeller can chime in when she gets to it because I think there's some pieces there. Let me touch on one issue. The big dynamic. We don't have a problem with Washington law so much because Washington is a bit of a haven state. But for many people, they don't understand that, and this is the danger. We're a federalist society, right? States are highly independent in their local governing laws, and no particular state can dictate what happens in another state. But because of that, you can get a patchwork of states with different laws in place and different protections. So you have students here who are present in Washington who are fully protected but may not be protected in their home state. And now federalism says, yeah, you can't do much about this state by state issue. But then there's the other problem of federalism is that when someone does a name change here, the 10th Amendment, the full faith and credit clause, are supposed to require those other states to recognize a lawfully passed and changed name in another state, just like they're supposed to respect a marriage certificate issued in one state. But as we've seen, and maybe this is the big challenge in the legal system in the 21st century, and I would say over the last decade, when we were fighting in eventually to Obergefell and the marriage equality cases, that a pick and choose sort of rejection about what they'll accept as federalism and states' rights and what they won't based upon viewpoint perspectives. And that creates a very dangerous environment for the individual. Every time that's happened historically, if you look at the history of civil rights movements, when you've had a patchwork situation, you run into individuals who are harmed, and then that's what usually creates the cases that will result in changes under federal law, or not, depending on how the political winds are moving. And it is dangerous. So all we can do is all I think we can do as individuals in Washington and as institutions like the university is do as much as possible to maintain privacy and screening of people when they're engaging in a public forum, right?
Right.
And some of it we have to do for ourselves, especially if, for instance, many people wouldn't share their pronouns on a Zoom screen like this because it's open and people could see it. And so some of it's self-protection and some of it's the institution being able to offer some privacy protections. But we also see an erosion of privacy protections too. And what the companies that administer the platforms are willing to do dependent on who's in charge. So the short answer is it's a free fire zone, folks.
Yeah, I'm going to actually ask another question out of order because it's a natural segue, which is you talked briefly about Obergefell and Orleans Flowers. Orleans Flowers, for those of y'all who did not take my law class, that was a case that prohibited in Washington state discrimination of individuals by businesses of more than eight or more employees of same-sex couples. So this was a case where a same-sex couple tried to get flowers for their wedding, got denied, and that was upheld by the United States Supreme Court. 303 Creative Limited may have caused a wrench in that case. That was a case of a Colorado website designer who said that it is my artistic preference to deny, and you cannot dictate my artistic preference for building websites because that's compelled speech. What do you think that 303 Creative Limited creates for the future of Orleans Flowers and even Obergefell?
All right. So here's the dynamic that's existed in LGBTQ rights, trans rights, marriage rights, the tension that's always been out there, and it's been in existence. It goes back centuries because it was also the reason for the anti-Semisogyny laws, the interracial marriage laws or prohibitions. So it goes back a long time. The tension is between the individual privacy rights and autonomy of people to be able to enter these relationships and the state protecting them as a general law of application versus the other side of the tension is people who believe that their speech rights or their religious liberties are impaired by recognizing these things that their religion prohibits them from recognizing. That tension has always been there. And up until the last 20 years or so, largely the interpretation has been the generally applicable law trumps the individual liberty unless it can show that it's causing a particularized harm. Well, the legal precedences have been eroded in that respect, and they're starting to elevate individual privacy and First Amendment, both speech and religion, to give them more teeth, which puts us in a very chaotic position. And there's an article about 15 years ago directly on this subject, which says that if it gets to the point where a single religious objection to conscience based on firmly held religious belief can trump the generally applicable law, then we're looking at chaos in our legal system. And so,
Well, we're looking at overturning a Brown v. Board of Education, because that was originally
correct. That was the Brown versus the Board of Education was the one that essentially started the doctrine that said, this is how it goes.
And Loving versus Virginia.
And Loving versus Virginia and a few others. And so the question is, and so let's be clear, folks, that from an intellectual standpoint, nothing has happened to the solid foundation of understanding that when people pass laws about protecting individual rights and liberties, the right to marriage, the right to associate with people of your choice, and that law is still solid. What's eroding is the belief that it should be applied even over someone's religious belief where it has no impact on them directly. And so letting people accept out of generally applicable laws, that's the new trend, and that's the erosion. And so I think in many respects, that's going to be where we're at. And that's the one that doesn't have the good intellectual underpinnings and why it should be. Because when it comes down to it, whether they overturn Loving is going to be the same reason as if they choose to overturn other precedents.
And just to be clear, Loving versus Virginia was the case that overturned the ban on interracial marriages.
Interracial marriage, yeah.
And yeah, and there are still certain municipalities that have a ban on interracial marriage within their criminal code, by the way.
Yeah, they just don't enforce it because
they
of
don't
Loving.
enforce it. Mm-hmm.
And so when it's like when they overturned the Roe versus Wade, and a lot of those old laws just came back into effect because they were no longer suppressed by the Roe decision. Mm-hmm. It's showing that it's a political decision by the Supreme Court as to how far they will go and what the system will tolerate for this sort of carving out backwards into the progress made. So, frankly, it's a very dangerous time. And so I just would point out that as people look at these issues, can if they could put the Roe genie back in the bottle, they could put any one of the other rights back in the bottle.
Mm-hmm. Thank you. I wanted to sort of condense the next couple of questions because I recognize that we're short on time and I want to respect your time. We're going to sort of pivot to the immigration law issues on the question. One of the first questions that came up was related to domestic violence. And this is 5 and 6 are related in that, what are some patterns as a judge that you've seen from the bench without stating anything about specific cases that a lay person or a friend can be on the lookout, especially if immigration status is an issue. And related to that is a lot of immigrants are afraid to go to court to assert their rights because they're afraid that even in an unrelated matter, like a domestic violence petition or a domestic violence criminal charge, that their immigration status will be used against them. As a judge, can you explain the rules pertaining to an attorney or pro se litigant attempting to use immigration status against a party or witness here in Washington State?
Sure. In Washington State, there are a number of provisions that prevent parties, lawyers, or individuals from raising the immigration status of another party or witness unless it is relevant to a specific legal matter. So for instance, and there are two protections. The first is a rule of evidence. ER 502 prevents admitting any evidence of immigration status unless it can be established that it's relevant. And in order to bring it into court at all, the party who wants to offer it has to do what's called an in camera review, which means they have to submit something off the record to the judge and give the other party a chance to respond as to what it is they want to offer and why they believe it's relevant for an issue that the judge has to decide. The judge then gets to decide whether it's admissible without bringing it into the public record, so to say, right? And it's very hard to make that record. There's very, very few things in most of the legal issues in state courts where their immigration status is relevant. It's very few, and a very limited weight. The other thing that goes into it is that under that rule, the court can impose the costs of dealing with the motion on the party who brought it if they thought it wasn't properly brought, so that the person who's alleging it can be sanctioned the costs of the other person's attorney. And there's also another rule of professional conduct for attorneys that states that if it's a RPC 8.4, if they bring up immigration status in an inappropriate fashion, they could be sanctioned by the state bar and the Supreme Court for doing that. They can put their license at risk if it's egregious. Now, that's the baseline rule. Let's deal with where, and I'll let IFJC talk about this more because it's in their wheelhouse. Often this comes up in state courts in a couple of ways. And it comes up in family law context with international families. And it comes up in the criminal context sometimes, the Padilla-Sandoval issues as to whether or not the involvement in the criminal justice system may result in a basis for deportation, exclusion from admission, or denial of naturalization. And that's kind of the two most fundamental areas where it happens. But if any individual who's not a U.S. citizen is involved in a court case and someone is trying to point out their immigration status to try and gain advantage, they should feel free to object to the court and say it's improper.
Thank you. And thank you for answering Padilla and Sandoval in a nutshell. A follow-up question to that is Padilla and Sandoval, if a defendant is guilty of what the USCIS determines to be a crime of moral turpitude, that could be the basis for deportation. That might change as far as what is considered a crime of moral turpitude, depending on what the administration defines. But historically, what are examples that are crimes of moral turpitude, if you feel comfortable answering?
Well, and Diane, who probably deals with more immigration side issues, deals with the consequences of Padilla and Sandoval far more frequently than I do. My main thing, my court is an entirely criminal court. All I deal with is misdemeanors, gross misdemeanors. And so I mainly have to ensure that before someone enters a plea, that they've had that discussion with an attorney, ensure that their rights are protected. They've had the discussion with the attorney before I can accept the plea. But essentially, a crime of moral turpitude is any crime that can give the impression that you've been dishonest or intending to defraud. That's moral turpitude. So the ones that are per se moral turpitude: theft, taking the property of another, making a false statement to a public officer. That's in essence lying to a public officer. A few of them like that. Now, those are crimes of moral turpitude. But remember as well, there's another category under immigration law that can be a bar to naturalization, and permanent status is, I mean, domestic violence. A domestic violence conviction of any kind can be very fraught, and I'm sure Diane will talk about that a little bit. So it's not just moral turpitude crimes. Fraud is another moral turpitude crime. Um, uh, Things like that. So, but domestic violence, certain violent felonies, certain types of assaults, like even a simple assault that's not domestic violence, but it has a vulnerable victim. That can.
And I also want to be clear that in pleading guilty to an even non-related charge, Judge
Yep.
Guy,
Yep.
like if you're pleading guilty to trespass, right?
Mhm.
And you have a charge that is under probation terms or a plea deal
Mhm.
in a different court for something that got pled down to what was originally a crime of moral turpitude,
Mhm.
and it got pled down to, say, a simple misdemeanor that was not a crime of moral turpitude, the original charge couldn't come back if in the interim you commit a crime that violates the terms of probation.
Yeah, that's an unusual issue. So it all depends upon how the diversion agreement was created,
Right, right,
right?
right.
If it was like a stipulated order of continuance, was
Yes.
it a deferred prosecution where
Mhm.
they agreed if you successfully complete it, we'll reduce the charge at the end of it, and but if you don't successfully complete it, we're keeping the original charge. It
Mhm.
all depends on the nature of the agreement. But there's also another issue at play that has nothing to do with how the court responds. It's the policies set out by the federal immigration courts,
Mhm.
uh, as to, because that's run by the executive branch of the federal government. The immigration courts are executive branch courts.
Mhm.
Those, they could have all sorts of different policies that apply as to, uh, even though you take, let's say you take a domestic violence charge, you plea it down to a non-domestic violence charge in order to avoid the immigration issue. Fine. But then you get to the immigration court later, and they're going to just look at it, and maybe they have a policy, and it's shifted depending on administrations, and sometimes the region of the immigration court you're in. You can have a judge there at the immigration court say, I'm allowed to look through the plea taken and look to the underlying facts of the case and say this was domestic violence, even though you pled to something that wasn't. And
Yeah.
I'm sure Diane can talk about that. That's a hot source of contention.
Mhm.
And so it's always fraught with peril.
I have one last question for you, and before we move on to Diane, is what are practical ways that faculty and staff can do to help trans and international students, given what's going on um, currently? Um, what are practical ways that we can help our students?
Um, wow, that's so much there. And there's a couple of speakers on the trans impact and legal issues. It would be far better than I. When I was in practice, I was mainly involved in family rights issues, and things like that, LGBTQ issues. But here's the thing: anytime you have an institution like the university, all right, and you're playing in an environment where you've got international students or students from other jurisdictions, other states, other countries who may come from more repressive cultures. You have to, and especially when it comes to the trans issues, if you've got to do as much as possible to provide safe spaces when they're being when they're being out, and their privacy cannot be protected, and you also have to provide mechanisms to preserve privacy. So, like one thing, can you restrict the attendance in a particular Zoom room, right? Well, and so that you can prevent people coming in and doing something with it. Well, yes and no. If it's an enrolled class, you can restrict enrollment just to those invited students and whatnot. Is it more of a public forum? Well, then you can't. And then you maybe want to moderate how people show up in that room.
Right.
and give proper disclosures as to the fact that this is a completely public forum, open
Yes.
to everyone. And so having good announcements about the levels of privacy expectation in a particular electronic forum or in a particular class. And then everything else is it's it's harder to address, right?
Yeah, it's tricky. I do for the whoever asked that question, I do have on my syllabus that a very clear warning that it is a crime to record somebody without their consent here in Washington State. So if you take a surreptitious recording of the Zoom and blast it to others, that is grounds for an automatic F in my class if I find out.
Yeah. Oh, here's a good thing for you too. It's a consent state, and that's why Zoom, for instance, always has the announcement go on when somebody hits the record button. It automatically sends the announcement you're being recorded. And by doing that, as long as that announcement goes off and nobody objects, then the recording is considered to be acceptable and it's not a crime. So as long as there's some objective and constructive notice that you're being recorded, then it won't violate the anti-recording provisions of the state code. But it has to be objectively and reasonable notice, and the person has to have objectively and reasonably consented by staying and participating.
Yeah, I also mention in class that it is that I am required by state law to refer to students by the correct pronouns.
Yeah.
Because it is considered under Washington state law, I am legally required to not discriminate against students based off of their gender. And
Yeah.
Washington state courts have interpreted trans status as a form of gender. So
Yep.
it's very clear in Washington state law. So you can hide behind the law if you want to. You can say, I can't break the law. This is what the law says. So please don't expect me to break the law. If you don't feel comfortable outing yourself as a trans ally, you can also hide behind Washington state law and the Washington state legislature. You can say, if you got a problem with that, write to your representative.
Yeah, and that actually takes me full circle back to procedural justice. When I'm in a courtroom and I'm dealing with a trans member of the community, I had one just 2 days ago come in for an arraignment, and their birth name is in all the records, and they haven't effected a name change yet. And so as soon as I saw the individual in front of me, before I even called the case and announced the arraignment, I asked them if they have a preferred name that they would like reflected in the records, so that allowed them to tell me their preferred name. And I always fill it in on the form, even though because there's no legal name change, the birth name has to go on the overhead. I put in as an alternate name within all the documents that it should be referenced as this is their proper name now.
Right.
And
Yeah.
so that's procedural fairness in a nutshell, right? Is talking to people in the way they wish to be addressed. Or I have 148 languages in my courtroom, right? Over the course of a year, 148 different languages. I don't speak all of those languages, but I've learned to do greetings to everyone in quite a few of those languages, where I'll greet them when they come into my court in their own language, because that is procedural fairness. That's letting them know you're welcome here, right? And then I have interpreters to help.
At this point, I'm going to bring in the IFCJ. Diana has told me she's encountering some technical difficulties. So Hiroko-san and Terry, are you online? Are you able to hear me?
Yep, I am.
Thank you so much. So I'm gonna until Diana has let us know that she is ready to present, I'm just going to continue on with my questions, and Judge Guy, please feel free to jump in when and if you're ready. I wanted to talk about the IFCJ. Let's switch gears. What is the IFCJ? What kind of cases could you handle, and why did you get involved?
So it's actually IFJC,
Oh,
Laura.
sorry, ISJC. JC. Oh my gosh, did I
No,
just?
no, no, no.
I
It's
typed
okay.
everything. ISJC. Thank you.
It took me a while to remember, the acronym as well for myself. So it stands for International Families Justice Coalition. So I am Terry Kinjo. I am the executive director. So I took this role last year, June in last year. Until then, I was working in the IT sector for over 25 years. And so I have seen it all. I've done it all. So I took a sabbatical, and one of the founders of the IVJC approached me saying, "Hey, Terry, I know you're not doing anything." I'm like, that's kind of nice to say. But anyways, would you like to kind of apply for this position? And I've known IFJC from the um, when it was founded back in 2017, I believe. So we've been doing this for about 7 years. And IFJC actually helps indigent immigrants who are going through the very complex family law issues, namely divorce cases, custody, whatnot. And we are funded by mostly right now by the state of Washington. So we can only support the people with the poverty level guidelines that are set by the federal government. But to answer your question, Laura, how I was involved in this one, like I said, I was asked for it to apply and applied. But 20 years ago, yes, 20 years ago, I went through the same situation that many of my clients, our clients actually are going through right now. Um, so I was married to a US citizen, and we got divorced, but it didn't end up there. I wanted to have an amicable divorce, but it didn't happen that way. And I was accused of child abuse, as well as the spousal abuse and all that kind of stuff, which never happened. And of course, my immigration status was at stake
Mm,
because, like Laura mentioned at the beginning, I'm from Japan. I still hold Japanese citizenship. Japan doesn't allow dual citizenship. That's why I am still Japanese citizen. Anyways, so the other party tried to manipulate the fact that I would be a flight risk. I'll take the children to Japan. I'll never come back. 20 years ago, Japan was not a signatory on a Hague um, convention. So yes, there was, but I established myself here after I graduated from high school. I moved here, and all my life was built here. So there was no reason for me to actually go back to Japan. And but of course the court had to consider that point from whatever the other party suggested. So, I was restricted to go to Japan for a couple of years during the divorce process. And then I was not allowed to take my children to Japan for a year after the divorce was finalized either.
And just
I
going to
know.
jump in and say, Terry's experience occurred before the changes in the rules of evidence and the rules of professional conduct prohibiting this kind of behavior.
Oh, okay. Yeah. So anyways, that was used against me quite harshly. I only survived because number one, I was able to speak English and understand English just fine back then. So that point, I was actually quite fine. Another situation was the other party, although undiagnosed, was dealing with mental health issues, namely personality disorder. So I knew that fact beforehand, when our divorce started. So I was able to actually dedicate myself to research quite a bit on that issue, how that can affect the divorce processes and stuff. And luckily, I was able to find a support group online, and I was able to join that one, so discuss, and found out there's so many people who are going through the exact same scenario. The patterns are very clear. So it was my job to let the court and the involved parties, such as police, other people, to let them know there's a behavioral patterns that are not best interest for the children.
Right.
So the 3 rules when I was going through that was a document, document, document.
Mhm.
Anything happens when I had to interact with that party, that I had to document, like date,
Right.
time, place, who was there, and what happened.
Mhm.
And of course, by that time, we had iPhone. So I was able to actually jot everything down in note section of the iPhone every time something happened. And that came really in handy afterwards, because chronological record that I was able to show to my lawyer to build my case against the allegations the other party was making. So yeah, so involving with IFJC is very rewarding experience for me so far, because I could see what our clients are going through. And um the funny thing was some of the clients actually mentioned to me that they can actually trust me more than they can trust their lawyers, which is kind of funny. They should trust their lawyers as well.
Yes.
But I think I come from more of the emotional support side, because I can totally see what they're going through, especially when they're not able to speak English fluent,
Right.
because judicial system is pretty much, I think it's common to everybody here. It's pretty much a black box to everybody. So once you got, involved with the judicial process, court process and stuff, you don't know what's going to happen next, and what the process is going to like, and what outcomes would affect how, your life is going to be afterwards and all that kind of stuff. So, I could all see that fear in our clients, and it's rewarding that I could actually support from that aspect as well. So.
Thank you so much for sharing.
Yeah.
I'm so sorry you went to hear that you went through that. I had
No,
no
it's
idea.
okay. I learned a lot, and
Yeah.
I ended up having a full custody, so.
Congratulations. I want to know, this is something related to what you just said. Even though that was not the case in your scenario, oftentimes in mixed status relationships or marriages, um, one way that one party will attempt to use the other party's immigration status against them in order to exert power and control is immigration status. And what are ways that you've seen IFCJ's attorneys even the playing field in cases of domestic violence, such as threatening to kidnap a minor in the family?
Mm.
And what are ways that your organization can assist someone like one of our students who might be a household member in this kind of situation?
You want me to cover that one, Terry?
Yeah, you can.
All right. I'm I'm one of the founders for IFJC, and I remained on its board until I became a judge. And my co-founder, who still is involved, were both attorneys who had seen lots of cases involving immigration, mixed immigration status families. A number of ways that it's used and it's all on the domestic violence spectrum. And if you don't know what the domestic violence spectrum is, it's a well-recognized psychological and sociological dynamic about a range of behaviors that are constituted as domestic violence for purposes of the behavior going on. And it stems from control of the individual financially and socially, all the way to actual physical violence. All right. And there's a whole range of behaviors. That's the spectrum. One of the things we've seen for immigration status, refusing to renew a visa status for a spouse, when you know that you're about to file a divorce proceeding. So essentially, during the divorce, because their status wasn't renewed, they automatically lapse and have to go home in the middle of the divorce or stay in country without proper documentation. Controlling the passport, not letting them have their passports, controlling the children's passports. All right. Another way is to, it's asserted quite frequently, the immigrant spouse comes from a country that is not a signatory to the International Convention, the Hague Convention. If they're not a signatory, then there's no power for the American court to direct that other court in the other country to force that person to return children. When that's the case, it's often alleged that, oh, they come from a non-Hague country, they could flee to the country with the kids, I'll never get them back, so give the kids to me right now. So there's all sorts of things like that that can happen and really there's no basis for the belief that the person's going to abscond with the children. They rely on the worst case scenario. They use perception, and quite frankly, in the courts, it has sometimes worked. Because and one of the reasons IFJC was formed was to not just represent individuals, but to educate lawyers in the judiciary on how the Hague works and how these situations work so that they don't make mistakes based on perception.
One of the things that I was curious is, we're about to enter some unprecedented sort of minefields as regards to mixed status families. And we're wondering, is there a foreseeable need for creating family custody and asset planning services given foreseeable roundups of family members who may be mixed status families? So for example, suppose one of our students comes up to one of us and says, I'm worried my parents are going to get deported, or one of our, what is the mechanism for me as an American citizen to take over as custody of my younger siblings who are also American citizens so that our family is not broken apart?
Yeah, so that's a good question. FJC also recognized that part of the proactive custody and asset planning services. So we are going to actually explore partnerships with the estate planning and immigration attorneys to help families prepare like custody, agreements, guardianship plans, standby guardianships, and parental power of attorney, and financial arrangements, etc., etc. We're not offering these services yet, but one of our board members actually told me that she's able to actually assist in developing these initiatives. So yeah, we are looking into that one because, Laura, I think you're correct. We are actually going into the landmines of the political arena starting this year. But yeah, that's actually a good question. And it's, like Judge Geip mentioned, the immigration status cannot be used, during the divorce proceedings, and IFJC attorneys are vigilant about, objecting to any comments, arguments related to the immigration status, so that, our clients are treated fairly, and the focus remains on the legal merits of the case. So, yeah.
Thank you. I wanted to know, are there, we had a question come in, and I apologize, this wasn't on the list, but I think this is relevant, is there are some colleges who are advising students from mixed citizenship families to avoid applying for FAFSA if it means listing their parents' addresses and information on the form. Is this something that we should be adopting? And I know this falls under probably legal advice. I don't know if this is something you feel comfortable answering, or somebody else on the panel wants to jump in.
I think Diane should answer that.
Okay, all right. We'll save that one for Diane. I'm going to ask the last couple of questions on related to IFCJ, and then maybe open it up for Diana, who I think has figured out. Hi, I see you. Has figured out the tech issues, which is, are there any specific issues that we have a lot of education faculty members that you see affecting young children who may be household members as far as, and this might be a Hiroko question, as far as mental health, like, how does that affect the whole family if you're worried about immigration status and
Yeah.
status of a trans person?
Yeah, so I can talk about not the legal things, but the mental health stuff. So I've been working with the families affected by DV, and it's like a lot of immigrant families, and they have huge trust issues. Of course, they have cultural differences, language barriers, and like they feel isolated. Of course, the DV that Judge Gayap explained of a whole spectrum, and they don't even notice that is actually the abuse, because like financial abuse, and it's like restricted. It's like sometimes like with like 5 family members, they're only giving like $500, and it's like including all of those food and then expenses, and like and that sometimes the victims get accused to use like 1 more cent of the money and stuff, and they don't even notice that's abuse. So that it's like like sometimes if we feel necessary, that agency will provide like each therapist it's like one-on-one therapy for each kids, and then also, of course, like the victim and also the family therapies. And it's like we will like sometimes work with a team, and most important thing is like confidentiality, because it's like in the therapy it's all confidential, but it's like we will care like extra care about the confidentiality, is like confidential address, and really really careful about like some people will come to the office and stuff like that. So
Thank you. Yeah, and the other thing that you mentioned, you kind of touched on this, was sort of stigma, cultural stigma, and seeking help. And
yeah.
could you maybe expand on that a little bit more, and also recognizing certain things as domestic violence that you might not think are domestic violence?
Right. Yeah. So the cultural stigma is like some cultures like it's like a seeking for help is like show us weaknesses, or like you're not good enough. So that it's like people who hold on for a long, long time. So it's like we really wish that oh, it's like if you come much earlier, that would could do anything. But it's like usually like people come in the kind of when it's too late, or sometimes like I can't really details about my clients, but sometimes they lose custody because of that, how they kind of present in a court. And maybe it's like the judge doesn't really know about what's going on, and it's like those victims pretty much appear like disorganized and dysregulated, and it's like maybe it's like it look like they're not really capable of the parenting, so that is like a being in a bad position. So that's
Thank you.
yeah, that will reinforce their self-image, and that's even more like developing the stigma.
So thank you so much, Hiroko. I want to know, and this is the last two questions. Number one, what are other areas of domestic violence as it affects international families, in particular our international students who may be teenagers, that you didn't cover, that that your organization serves? And also, for students who want to help, are there internships available for students who speak more than one language, which ironically, most of my students speak more than one language and come from immigrant families, or they could volunteer with your organization?
Yeah, so that it's like there are so many places. Like, but for example, if I'm at the east side, I'm located in the east side, and LifeWire is like a DV agency, so they're looking for the volunteers and stuff. And I think that in the Seattle side, it's like New Beginning and bunch of others. Like you can search like DV agencies, and if you're interested in, please like contact them, and you know like volunteer.
And Terry, volunteer opportunities with the International Family Justices Coalition.
Yeah, so again, we're looking into the opportunity to develop that kind of program, but currently because we don't have we don't offer internships for bilingual students interested in a legal career or to earn school credits for the volunteer work. But we do welcome students to observe hearings alongside our attorneys when it happens, or shadow my work on a specific, scheduled basis. So you can actually see what I do and what we do. And also, we actually highly recommend the students, bilingual students, to actually get certified as a court interpreters because we
Mm.
lack resources in that area. And like Judge Geip said, the court has to offer
Mhm.
the specific linguistic help
Mhm.
when those clients come in who could not speak English and stuff. So, and that will actually, give you the segue to the legal career, and as well as, and I believe that the court interpreters committee was established by the past Supreme Justice Gonzalez, I think, of the Supreme Court of the Washington. So yeah, that would be actually good networking as well too.
Thank you. And for those of y'all who are interested in connecting students with that particular job opportunity, you can reach out to me, you can reach out to Judge Geip or Terry. But that gig is $70 an hour. So if you want to make $70 an hour, it's a pretty good gig and you can work from home. You can work from anywhere. I've seen court interpreters call in with their cell phones.
Yeah, you actually have to go through the court certified program that's established by the Washington State Bar Association and the courts. But yeah, I think it's worthwhile.
Thank you. Thank you so much, Terry and Hiroka-san. As I said before, feel free to jump in the chat if you have questions. But at this point, I'm going to hand the reins over for moderating the discussion to my colleague Chingin and also to Attorney Muller.
Hi, thank you so much, Laura, Terry, Hiroko, and everyone for being here. Thank you so much, Attorney Muller, for being with us.
Hi, Chingin. You can call me Diana.
Okay, thank you, Diana. Are you ready to begin?
Well, this was a little bit of a technology adventure, but yes.
Uh-oh, I think you muted yourself.
Okay, can you hear me now?
Yes, you can.
Okay, I can't believe I'm doing this on my phone when I have two monitors and both of them went out. I don't know.
Oh no, well, we're so happy you're here. It's happened to all of us.
I'm delighted to be here, and I'm delighted to share some information. And I heard my name was mentioned a few times, so I look forward to not knowing what I was supposed to add, but you can tell me what I was supposed to add, or Professor Umetsu can jump in and say, Diana was supposed to say this.
Yes, I've asked my colleagues to add those questions to our question list, and hopefully we can get to some of those questions. So let's start off. Can you talk about what are some legal rights that immigrants have if ICE comes to their doorstep claiming that they have a warrant for arrest?
Absolutely. It's very important for immigrants to know their rights. A lot of people who come here, especially if they come undocumented, they are really oppressed by bad labels and name calling and exploitation. So they don't think they have legal rights. But if you're in the United States and you're outside what's called the Constitution Free Zone, which I will talk about a little later, you have the same constitutional rights as any other being in this country. So if ICE comes to the door, you can ask their names and their badge numbers. They entirely may not give them to you. They may be in plain clothes. In this country, police are allowed to lie to people, and ICE, they enjoy doing that kind of thing. They have been reported to say a lot of things like when they go to apprehend immigrants, they're hunting. So they'll be devious. If they say they're there to see a particular person, ask if they have a warrant. It must be a judicial warrant. It can't be an administrative warrant. If they're holding like a folio or a file, they might have their shopping list there. They might have something from their kid's school. They might not have any papers. So they need to show you that judicial warrant. And there's a couple ways they can do that. If there's a window next to your door, they could hold it up to the window. You can take a picture of it and send it to a lawyer if you have a relationship with a lawyer. They can slide it under the door. If they don't do that, then you simply don't consent to them coming in. So there's ways to, have them show their ID to a window. I'm sure they would not pass ID under a door, but they can show the warrant, they can pass it under. And if it's an administrative warrant and it has not been signed by a judge from the federal district court, then they don't have a valid warrant. And they know it, but they don't like when immigrants know that. Now, in circumstances where it's a mixed status family, the family should develop a safety plan. They should have family planning. And I know that the folks from IFCJ, I hope I got that right, they talked about asset and custody preparedness. Really important to have powers of attorney if the family has assets so they can be sold. And if one member of a family has a deportation order and there are other undocumented members of the family, they may have to make a decision if things get tense enough that that person goes out to deal with ICE and they close the door behind them so the rest of the family doesn't go out. Now, the nominated secretary for the Department of Homeland Security says they are happy to deport families together, and there is a procedure for this, but that means also deporting U.S. citizen children, and I find that very offensive. But that's what I would do. I have other suggestions if you want them, or we can move on to the next question.
Let's hear the other suggestions.
Immigrants in all statuses should stay informed but avoid panic. Stay updated on immigration developments. And since this is for a university, it's very important to exercise critical thinking. Make sure that you're using reliable media sources. Something somebody said about the California fires was, if there's a rumor, check 3 news sources. I'd say at least check 2 mainstream reliable news sources that publish all the current stuff. Univision is a Spanish channel, and I enjoy watching them, but they often do this report about a form of relief that isn't available the way they say it is. And then clients will start calling and it's like, oh, they did that report again. So check a couple different sources before you panic, and then, take reasoned steps after you've gotten information. Don't disclose your information, your immigration status if it's not required. Driving is a privilege. Immigrants, even undocumented immigrants, can get licenses in this state. And the information that you don't have a social security number is associated with that driver's license, plus a lot of other federal information. Nowadays, big data dives in. So they get a lot of information and they probably know, but they won't specifically be told, this is an undocumented person I just pulled over by the road. So you have to disclose your driver's license if you're stopped, but you don't have to disclose your immigration status. And the right to remain silent is enshrined in the Constitution in the 5th Amendment. And a lot of people think they can talk their way out of stuff. I remember an article I read about even a criminal defense attorney who thought she could talk her way out of some sort of citation. And she talked her way into it. The police, if they're talking to you, they have some sort of information that you don't have. The best thing to do is just to say, here's my license, here's my insurance information. You want to make sure you're following the law. And then don't ask questions, don't offer anything, accept the ticket and go on your way. If they won't let you leave, you can ask, am I under arrest? If they say no, then you say, am I free to leave? Even if they stop you walking on the street, you just say, I don't want to talk to you right now. I do not want to speak with you. I need to leave. Am I free to leave? You never want to run. You just want to very simply, am I free to leave? Okay, then I'm leaving. Don't tell hospitals because they can't legally require their employees to remain silent about immigration status. And there may be employees, unfortunately, who would turn someone in. If you're undocumented and you happen to be working for an employer, you really shouldn't tell them because they shouldn't be employing you, and you know you're working under the table, so keep it quiet. Anyone who does not need to know, you don't need to tell. Keep detailed records. A lot of immigration cases revolve around immigration documents, tax filings, proof of residence, employment records. Keeping digital copies is a great way to access them quickly and have access from multiple places if you don't have a paper file. I talked about creating a family preparedness plan, and I think the other speakers probably already talked about the fact that immigrants have equal access to the courts in this country. So if they need to file for child custody or a third-party custody order, they can do that. And in certain, for example, sanctuary cities, the county, for example, King County does not allow ICE to go into the courthouse. They want people to feel free to get protection orders, divorces, adoptions, whatever they need to do, their business in the court like anybody else without the threat of ICE being inside. ICE can wait outside, which is sometimes a problem. But it's in sanctuary type counties, it's a lot safer than it is in non-sanctuary type places. And families with mixed status should definitely prepare, have a meeting place if people get separated, have a strategy, have everybody understand you don't open the door. Teach small children who love to run, and once they can reach that doorknob, they want to run and answer the door, teach them not to. If ICE does enter your home, you just say, what are you looking for? I don't consent to you being here. I don't consent to you searching. I want you to leave. Don't argue, just repeat those kinds of words. There is a website. It sounds like IFCJ has a lot of resources. There's a website called Appleseed, and I'm preparing a handout that I will send to Professor Umetsu, who can distribute it liberally. Appleseed 7 years ago did a great workbook that they have one for assisting practitioners and one for pro se people to pre-plan for assets and custody if somebody does get deported. And yes, if you're old enough and you can support a child, you can take custody of a sibling. It would be very hard for them, but they can do it. If you're on a visa, so you're not undocumented, like an F1, you need to stay enrolled full-time. Do not engage in unauthorized employment. That's very important because that is a violation of the terms of the visa. Follow all the requirements of the visa. You can have one semester where you fall below a full course load, but you need to stay in touch with your school's designated visa officer and your advisor. If you're eligible for permanent residency or citizenship, go ahead and apply for that as soon as you're eligible. Stay connected with community resources like IFCJ, Northwest Immigrant Rights Project. If you're in a domestic violence situation, get connected with a local shelter. And seek regular legal advice. It's really important if things happen suddenly that a client has a complete copy of their immigration file. So establishing a relationship with an attorney and getting a copy of that file now means you'll have it if you need it later. And if you file something with immigration, you need to keep photocopies, actual photocopies, not just printouts. Never lie to a U.S. immigration officer or judge, and please never ever lie to your lawyer. Those are my general pointers.
Thank you so much. And yeah, it would be great to have that handout when it's ready.
Yeah,
And we can send it out to everyone
fantastic.
who's registered for the call. Okay, so NPR reported that for many international students under the F1 visa or doing OPT, many universities are recommending that international students traveling home for the holidays return to the country before Inauguration Day. Why are they advising so?
Well, the primary reason is that it's much easier to defend somebody's rights if they're in the country rather than trying to get in. And if you, for those who follow immigration issues and might remember back to 2017, there was a Muslim ban put in place preventing Muslim people returning from lots of different countries to enter the US. It was ultimately defeated in court, but there were people, I mean, people try to enter the US every day. They're flying into airports and suddenly they find out there's this ban. And so some of you might remember that immigration lawyers went to the airports and fought out the case right there. And I had some friends on the East Coast. The Second Circuit Court of Appeals was the first place where a federal lawsuit was filed. They had been at a gala event, so they're in long ball gowns, taking their shoes off, marching down the hallway of federal court to file a late night action to stop that Muslim ban. And they succeeded. It was great. But the picture of them marching along in their ball gowns was pretty cool, as well as having my colleagues at all the airports fighting for people's rights. That's something we love to do. Undocumented people who've been here more than 6 months can't leave the US or they'll face a bar to returning, so they should not travel. Immigrants should consider, after the first 100 days, when hopefully the dust will have settled a bit, every immigrant who's on a non-immigrant visa like an H-1B or an F-1 should really consider the importance and the risks of international travel until we know what the next administration has in store for us. And I mentioned earlier, there is a constitution-free zone. So Customs and Border Patrol is allowed to enforce the Customs and Border laws, like who can enter and move around the country, within 100 miles of the border. So if you think of the contiguous lower 48, draw a 100-mile line all the way around it, including the coasts and the southern and the northern borders. That's a zone where Customs and Border Patrol roams pretty freely and can stop people. If you're coming in at an airport, they can absolutely investigate your computer or your phone. They can even confiscate it until they've reviewed the contents. And that's true for US citizens. But if somebody who's undocumented wants to travel to another state, they should try to go kind of through the middle, or at least up further than 100 miles so they're not encountering CBP. Because if they are encountered randomly, they could end up being detained or deported. So those are my pointers about travel. And if you're here, it's a lot easier to defend you.
Thank you. This leads us into the next question, which is, with the new administration, what changes should we expect for international students and trans students as far as their limitations and rights?
That wasn't on my list, but that's a great question. Okay. For international students, from 2017 to say about 2020, 2021, I don't think that administration appreciated the value of international students that they bring to the US. They bring money to universities, obviously, because they're paying full fare plus, but also they're bringing talent, innovation, entrepreneurial spirit, all of the things that the US has always benefited from in terms of immigrants. So when we had the pandemic, there were threats to their being able to attend classes remotely via Zoom, just like every other student. that was ultimately resolved in favor of the international students, but God forbid we should have another pandemic, then there may be a policy change that could impact them differently than regular students. In terms of trans students, that's kind of outside of immigration law. Certainly, trans students may be eligible to apply if they're international trans students. I assume you're asking about international trans students, correct? Or are you asking about trans students in general?
I think that was an audience question, so I think that was to all the
Okay.
speakers. So I think we're just getting your take on it. So
Okay.
I know your
So-
expertise is immigration, so it'd be great to hear about international trans students.
Okay, so I'm going to talk about international because I know they're going to try things. They're trying things in many states and trying to restrict rights, access to medical care for minors, lots of things. In terms of international trans students, if they're here on an F1, for example, they can apply while they're in that non-immigrant visa status. They can apply for asylum. So they should talk to an immigration lawyer and have their case evaluated. And certainly there are some countries where LGBTQ plus folks are better accepted, but there are some cases where there is a death penalty stated in the law if you are found to be LGBTQ plus. And so there can be some very powerful asylum cases. There is, and I may say this more than once, but it bears repeating, if you are going to apply for asylum, you have to apply within 1 year of entry or 1 year of the expiration of a lawful status. So DACA is not actually a lawful status, it's a deferred action. An F1 is a lawful non-immigrant status. So they wouldn't have to apply within the year if they're still in F1, but if they fall out of F1, they've got 1 year to file for asylum. Well, I'll talk more about the asylum process later so I don't duplicate myself. Certainly there can be some good cases made for LGBTQ plus discrimination. And I try to make my office a very safe space for clients to speak to me about whatever issues they're having. And I'm aware of the international scope and the Rainbow Underground Railroad, and I've worked with folks, lots of different clients. So I would hope they'd feel very welcome. But if they don't feel comfortable with an attorney, don't feel comfortable discussing such personal issues, especially, think about if the consequence in your home country is death, you may not have come out yet. So you want an attorney that you feel comfortable discussing those very personal issues with.
Thank you. Let's shift into talking about Dreamers. How has status for Dreamers changed over the years? What do you foresee the status changing for Dreamers in the near future, and what forms of relief might be available for legal status?
Well, I guess one of the problems I've seen is that status hasn't changed for Dreamers, and this is a source of great frustration. The incoming president has indicated he's supportive of Dreamers and thinks they should get status, but he didn't say anything specific. I'm glad he said that, at least that's supportive. We're still bracing for restrictions. If someone is here in DACA status, first of all, they need to make sure that they renew, and I'm trying to get all my DACA clients to renew before next week. Also, if they entered unlawfully, they should try to get advanced parole, travel for business, personal, or humanitarian reasons, business, academic, or humanitarian reasons, and then return to the US. And when they return to the US under a particular case law, they will have a lawful entry. And if they're married to a US citizen or a permanent resident, they would have a means to adjust. It's a longer, different process if you're married to a lawful permanent resident, but if you're married to a US citizen and you leave on advanced parole and return, you're then able to apply for permanent residency here in the US, which is a huge time savings and
Oh, Diana, we just lost your audio. I think you may have hit the wrong. Here, I'm gonna ask you to unmute.
I don't know what I'm touching because I'm talking on my phone and there's very few controls.
We
So
can hear you
apo-
now. Thank
I
you.
apologize. So if somebody entered unlawfully and they get advanced parole, depart and return, they will have a lawful entry and can apply for lawful permanent residence based on marriage to a US citizen here in the country. Now, there was a recent memo, so this is a policy, and policies can be subject to change depending on administration. So I'm not sure what's going to happen, but they have made it easier for US college graduate dreamers to get non-immigrant business visas through the consulate. So they have to go abroad and apply for a waiver for their unlawful presence time in the US and the business visa. And there's a lot of requirements for business visas, but they have at least initiated this policy that's supposed to make it easier and faster for dreamers to be able to do that. That policy could change. But it's been in effect for a couple months. Advanced parole may become harder to get. So, and the other thing is that because DACA was created by executive order and there weren't regulations published, and this gets into the nitty-gritty of administrative law, there's a court challenge, and I think 16 states sued that somehow having DACA people was going to harm their states. So that case is now with the Fifth Circuit Court of Appeals, which is not the circuit you want, deciding cases for anybody's rights. And oral arguments already happened, and we're awaiting a decision. On the competing side, the current administration went ahead and published regulations to make it kosher after the fact. And I'm not sure what's going to happen with that. What I hope is that maybe they'll finally come together in Congress and decide to pass a pathway to lawful permanent residence and then to US citizenship. But I'm not going to gamble on that. But I hope. Damien, do you have another question?
Yes. So what are other precautions that international students can take to protect their work, H-1B and or student F-1 visa status?
So I talked about some of them before. Follow all the requirements of your program. No unauthorized employment. So some F1s can work on campus, but they aren't authorized to work off campus during their period of study. Follow all your deadlines. Don't miss any deadlines. Don't violate your status. And if you're in OPT or you're in H-1B, a practical suggestion that doesn't have to be onerous would be to network a lot. Now, I know some people get shy, and especially if you're an international student, that can just sound like the most horrible thing ever, having to go talk to people. But joining clubs related to your STEM or a professional association, or going to meetings of local associations, because if, for example, if the economy tanks or there's a downturn, if you know people in your field and you lose your job, you can go talk to other people. You just pick up the phone and start calling. For OPT, you can be self-employed, and you can change jobs if the first one isn't suitable. It just has to be in your field of study. Now for H-1B, it's a specialty occupation, and there's a lottery unless you have a master's degree or you're going to do higher ed or nonprofit research. And the lottery is a lottery, hard to win. But for those who are successful in getting those visas, if they know more people in the field, they'll have a better chance. And I think it was 2 years ago at the beginning of the school year. The school districts were saying they were going to close schools because they expected a lot of H-1B folks to be leaving. And almost all of them I mean, there's no official statistics, but almost all of them found new jobs with other companies within the 60-day period for H-1B. So having those connections is really important. Do you have another question for me?
I do. What are crimes that, if convicted, will negatively affect individuals from ever successfully seeking legal status? What about marijuana possession?
Okay. I heard a little bit before the monitor went dark and my mood fell. I heard Judge Geip talking about this. So hopefully I won't be repeating. Even minor infractions can impact your immigration status. The consequences for a crime are very, very different for someone who's an immigrant, whether documented or undocumented, than they are for US citizens. So you need to get a lawyer and tell your lawyer what your immigration status is. You don't have to tell the judge, but you need to tell your lawyer so they can take action, coordinate with an immigration attorney to make sure you don't plead to something. For example, if there's going to be a plea deal, that you don't plead to something that could get you deported or make you inadmissible. I did hear Judge Geip talked about crimes of moral turpitude. So even something minor like a shoplifting can be an offense that would make you inadmissible. Domestic violence crimes, child abuse crimes, certain crimes of violence. You definitely don't want to engage in any terrorist activity or conspiracies, like you're talking to somebody who's talking about terrorist activity. You need to cut that short, say you want nothing to do with it, and get out, because even conspiracy or attempt count as crimes, the same as the actual crime, even if you're talking to somebody who's clearly mentally unstable or a fantasist and doesn't actually have any crimes. The government's very touchy about terrorism, and I get that. So any kind of crime. Now, I say this at the same time knowing that with immigrants, the rate of crime, no matter what politicians say, is so much lower for immigrants than it is for US born citizens that I don't worry much about the vast majority. But if you are out drinking with friends, do not get behind the wheel. At some point, they're going to pass a law that makes drunk driving an offense that will keep you from getting immigration status or repeat drunk driving. There are different state laws that make drunk driving a felony that can prevent you from getting status. And even based on discretion, when they're deciding applications, they can say, look, this person's had multiple DUIs and they haven't resolved their issues. So they shouldn't be allowed to stay. So it can be minor crimes. It can be much bigger crimes. You want to not commit them and take all the reasonable steps to make sure that your lawyer knows how best to defend you. If you must drink, if you're going to drink, stay home or arrange a ride, have a designated driver. Never drive intoxicated. It's not good for any of us if that happens. Now, there is a bill pending right now in the US Senate today, and I hope it doesn't pass today, and I hope when I get my computer fixed, it won't have passed. It passed the House, and I personally have messaged my US senators. It's called the Laken-Riley bill, and some of you may recognize that name. It's a young woman who was a college student in Georgia who was murdered by an undocumented immigrant. Again, crimes by immigrants are so rare, and we have 150 years of statistical history that shows that immigrants commit crimes at a lesser rate than US-born citizens. But this one guy is their example. So the Laken-Riley bill would not only target undocumented immigrants convicted of crimes, so convicted, it would also apply to undocumented immigrants who were charged but never convicted, arrested but never charged, like they didn't do anything. The police did not file charges. Mistakenly arrested because of a police officer's error, wrongfully arrested because of racial profiling, prosecutorial malice, or other unconstitutional motives, or a person faces charges that are later dropped. So this is like the whole spectrum of possibilities in the world of maybe getting arrested, maybe facing charges. These people under the Laken Riley bill would have to be detained in immigration detention without bond, so without the ability to get out. It is a sweeping act that disregards so many different levels of, I will provide a link. Well, I'm not sure this law is going to pass, but I do have a good article that explains it, and I will include that in the resources so people can look at that. I have a bibliography section. It's the Laken Riley bill. I'm really hoping the Senate doesn't pass it, but for some reason, the politicians think this is some great change to immigration, and it's not. It's not going to solve problems. It has sweeping due process violation and constitutional concerns, but it could end up with a lot of perfectly decent people wrongfully arrested or wrongfully looked at who are in immigration detention, which is just not a great place. Marijuana. So this is a surprise for a lot of people. And in Washington state, marijuana is legal, right? Not if you're an immigrant. Unless you're a US citizen, it is a violation of federal law to possess, use, sell, distribute marijuana. So this is a real trap because everybody thinks it's legal. It's still a controlled substance under federal law. Immigration is federal law. So no matter what the state law is, and it varies from state to state, so you absolutely, even if you're a US citizen, you cannot transport marijuana from this state, like say from Washington to Colorado, or I think it's legal in Oregon now. You can't drive it across the border because that's, oh, Gavin is giving you all the Slate article I was going to share, I bet. So marijuana is a very big no-no. Drugs are an absolute no-no because they are among the most serious of all crimes. And they can even make you inadmissible or deportable for a reason to believe that you're a drug trafficker. Not that you are a drug trafficker, but that the government has a reason to believe, which is very loose language that they bring up when they don't have an actual drug conviction or a drug offense that they can, or that they caught you with anything. They can bring up that they have reason to believe, and it could be sketchy intelligence reports, and they could try to keep you out. So do not possess, use, sell, or sell illegal drugs, controlled substances, or prescription drugs that are not rightfully yours. If you have prescription drugs that are prescribed to you, you can use them. You just don't sell, distribute, or give them to other people. Don't spend time or share space with people who have illegal drugs or controlled substances they're not supposed to have. Don't room with them. Don't get in their car. Because if you're in a car as a passenger, the police can still assume that anything found in that car is yours. And that can be very difficult to prove that it isn't if you're like, let's say it's under the front seat so the people in the back seat could reach something, and it gets discovered because the driver doesn't know they have a right to say no to a search. If it gets discovered and you're sitting in that passenger seat in the back seat, you could be said to be the person who possesses that, or the whole car could be charged with possession. So immigrants really have to be careful. Don't go to parties where people are smoking weed or using drugs. Do not work in the cannabis industry, which is a huge and very profitable industry. Do not marry or live with someone who's working in that industry, because all of those will cause problems with the ability to get lawful status. No drugs means no marijuana. I feel like a grandmother saying that, but grandmothers now are using marijuana if they're US citizens. It's crazy. Also, we have learned through some of the finer chemical points of how they divide up marijuana and how the law treats it, that even if you're getting CBD products, you can test positive on a marijuana test if they have Delta 8 or Delta 10 in them, and a lot of them do. And we are realizing that that's of great importance to people who are going abroad to a US consulate to apply for their status. Other points: do not smuggle anyone who doesn't have lawful status into the US. Sometimes one family member will come and then expect that family member to bring others. That is a violation of federal law, both under immigration and criminally. Do not claim to be a US citizen in writing or any other way. And as I said before, don't engage in terrorism, don't talk about terrorism, even with people who are just fantasizing. Don't hang out with people who talk about terrorism, unless you're maybe talking about how bad it is. How's that? Does
Great.
that answer the question?
It does. Thank you.
Okay.
The next question is, what about immigrants with TPS, temporary protected status?
This is a great question. And temporary protected status can change. If something happens in a country, say a natural disaster or political upheaval, the government can create temporary protected status, or something that's less commonly heard about called deferred enforced departure. Both of those will allow the applicant to get a work permit for the period of time designated because of the crisis. And I don't have the complete list because my computer went poof, but there's a bunch of countries in Africa that have it right now. Sudan, South Sudan, Cameroon. Can't recall if Ethiopia has it. And for many years, El Salvador and Honduras have had it, and that has been a subject of litigation. Nicaragua had it. Haiti has it. Venezuela, and I'm missing a number of countries. I think Burundi and Chad. I forgot Chad, sorry. But those periods expire. It's issued usually in 18-month increments for TPS. Deferred enforced departure can be much shorter, depending on what's going on. And even Ebola, there was deferred enforced departure when the Ebola outbreak was happening, because we didn't want people returning to countries with major outbreaks and being exposed when they were already dealing with enough. So that can be renewed, or it can be not renewed. There has been a push to get the current administration to renew current TPS status for many countries. Haiti and I believe Venezuela are about to expire, and certainly Haiti is still in a very violent state, and they've repeatedly suffered from earthquakes and other weather-related events that make the situation there quite dire. So I am really hoping, especially Haiti gets renewed, because it would be devastating to send people back there. Hopefully within the week, we'll hear something about that for those renewals, for the ones that are about to expire. And if students are in F1 status and their country, something happens and their country has TPS, they can go ahead and apply for that, because it could continue past their education period and give them more time while they apply for an H-1B lottery or something like that. Gavin is really on top of it. Thank you, Gavin. I appreciate that. And similarly, if you remember some years back, Libya fell and the dictator Gaddafi was murdered or assassinated. There were a lot of Libyan students in the US who had received favor from the Gaddafi government, who were then terrified to go back because it was very clear which families were associated with Gaddafi. So a lot of those students applied for asylum. Now, Bashar al-Assad just fell in Syria. I have not heard the same clamor about Syrian students needing asylum. I've heard more happy notes, but that's a very limited scope of news. I haven't focused on that. If something happens in your home country that means it would be dangerous, that you would face persecution if you return, you can apply for asylum. A change of country conditions is a reason to apply. So people in an F1 status, which is not, it's a non-immigrant status, it's not a permanent status, they can apply for other forms of relief if they come up. So I guess we'll listen to the news this week and see who renews, see if TPS status gets renewed before the inauguration or after. I would be less, I do not expect much renewal after.
Thank you.
Sure, thank you, Qingming.
So right now there are policy threats for mass roundups and deportations. How practical would that be? What would be the impact on the American workforce and our economy? What would the deportation threats cost if carried out short term and long term?
Oh boy, what a question. Well, according to the experts and my experience, I would add, but I'm not necessarily a mass deportation expert. It's highly impractical. When I've researched this issue, the current criminal apprehension and fugitive apprehension program from 2017 to 2021, so that's not this administration, but the prior administration, deported 30,000 fugitives, and that's with teams of ICE agents tracking down the fugitive. They have to monitor where they work or where they live. They make sure when they know they'll be there, and then they show up and serve the warrant or apprehend the individual and take them for processing. A threat to deport 13 million people would require at least 31,000 new employees at ICE. And they are hiring more employees, but will they get to that many, and will they be vetted? Because ICE employees must pass background checks and probably have security clearances for certainly for certain operations. It's been suggested that the government could use the Army, and maybe for a very limited time. I'm not sure about the legality of that, but maybe for a very limited time they could do that. In general, using the U.S. Army in the U.S. is a violation of the Posse Comitatus Act. The Army is supposed to be protecting us from external forces, not being used against the people who are in the country. But on a limited basis, it's possible. Certainly, National Guard could be called up. So I think, well, so there's the threat. I think it's very impractical. The cost estimate is for apprehensions of 1 million people, it would cost $88 billion with a B. They'd need 31,000 more employees. The detention cost, and a lot of the detention is now private companies. So there are private companies profiting off the detention, the civil detention. It's not criminal detention because they haven't committed crimes, or if they have, they've served their sentence. The civil detention cost would be $167 billion. The cost is about $150 a day to detain someone in immigration detention. And as I haven't checked prices recently, but some years ago we checked, and you could go on a luxury cruise for the same price. Maybe it doesn't quite work out, but maybe a stay at a luxury resort. So private civil detention is very expensive. If they had to build, they would have to build additional facilities and double the carceral capacity of the country. The US can incarcerate 1.9 million people, so they would have to double that to achieve their goals of deporting 1 million people a year. So I I ran a quick total and it was about 280 billion with a B dollars to deport 1 million people a year, and a presidential term is 4 years. So you're looking at $1,120,000 billion roughly, including flight cost, to deport 4 million people. But if they did succeed, the economy would be devastated. It would shrink the workforce significantly. For every 500,000 immigrants who are deported, 44,000 US citizens lose their job. So Americans will lose their jobs too. Smaller businesses will go out of business. There will be a massive labor shortage, which already triggered inflation once or contributed to it. So that would shrink the economy. Then if you look at specific fields like construction and agriculture, where there are a lot of immigrants, 1 in 7 workers in construction are undocumented, including CEOs of companies. 1 in 3 roofers, drywall, stucco, masons, and ceiling tilers are immigrants, undocumented immigrants. The prices will go up. People who need remodeling or construction, whether it's business or residential, will have a very hard time finding contractors, and the contractors will have a very hard time finding employees, and it could take decades to replace that shortage. Now, if you think of things like natural disasters, hurricanes, a lot of the people rebuilding after those natural disasters are immigrants, and they're willing to move to where the jobs are. If they're deported, things won't get reconstructed. In agriculture, 2/3 of our tomatoes and 90% of our avocados come from abroad. Americans are very touchy about anybody interfering with their avocado supply. We learned that a few years ago. The remaining 20% of the produce that is grown in the US is picked primarily by immigrants. So that food could be rotting in the fields unless we're all sent out, on some sort of forced labor activity to pick the food because there's nobody else to pick it. What I do expect, unfortunately, more enforcement, less discretion, so enforcement wherever they can do it. I expect increased apprehensions of people with orders of removal. Some people who have orders of removal from immigration court can apply for or have obtained a stay. When that expires, I expect they won't be renewed, and those people may be removed. If they have family, ICE will make a provision to deport the US citizen family members with them, which is deporting US citizens. But I expect that stay requests will be denied unless there's a really compelling reason. I think we'll see more raids on employers. There have been very few raids in the last 4 years, but they will be focused on employers that have a lot of undocumented workers or a known history of employing undocumented workers. And we probably won't see a lot of enforcement actions against the employers, even though they're the ones breaking the law. But they will try to round up the workers and find out their status and deport those who are undocumented. We may see raids on other group gathering kinds of locations. Historically, schools and churches have been off limits. And during the campaign, one of the candidates said that they would no longer consider schools or churches to be off limits. So that's a concern because a lot of people go to practice their faith and or they have children who attend school and they take their kids to and from school. We are concerned about retaliation against sanctuary cities in terms of, for example, restricting federal funding. Now, Congress has the power of the purse, so that's a trickier issue. Not everything can be decided by executive order, but I think the next administration will probably try a lot of things and they will get pushed back through litigation. If ICE is apprehending someone they consider to be a target and they encounter other undocumented individuals at that location, whether they're family or they're at a work site, you know, they just happen to be there. If they don't know to remain silent and or they can't prove their status, we anticipate they would get picked up too, because that adds to the numbers. You're still not reaching 1 million people with these smaller efforts. As far as I can recall, all of the presidents have always counted those who are expeditiously removed at the border. So they get a deportation order at the border, so they never actually get into the US. They count those people also in their deportation numbers, so it kind of puffs it up. But they will be trying a lot more apprehension efforts within the US. We're also concerned that there will be more denials of applications, slower processing. They will withhold favorable exercises of discretion if an application is based on discretion, and they'll probably find ways to make everything harder. Those are our concerns of what will actually happen. Do I think they can deport 13 million? No, but I think they can make life hard. And I think they will also use, if you think about regimes from other countries that have picked on a particular group, anywhere in the world, there's lots of examples I can think of. They use fear to really whip people up. So there was a raid yesterday in Bakersfield. It was by Customs and Border Patrol, and I communicated with a colleague there. I said, but you're more than 100 miles from the border. Yes, from the southern border, but not from the maritime border. Bakersfield is technically within 100 miles of the coast. So CBP carried out a raid. I don't know how many people were apprehended. It was a small number, but it was very public, very noticed, and that has people on edge. So they will be saying things and trying to make examples out of their efforts to keep people afraid. And what I want people to know is they have the right to remain silent. They can decline to have their car searched. They can decline to have their home searched. And they need to hold officials to their burden of presenting a federal warrant, so that they will have the best possible chance to not be caught up in an apprehension.
Thank you so much, Diana. So I'm looking at our clock. We have about 5 minutes left, and we have 4 to 5 questions. I'm wondering,
Okay.
are you willing to stay on a little bit longer because of our tech issues? Alternatively, maybe we could send you questions and then they can be sent out.
No, I'm prepared. I've got, well, you've added some questions, so I'll be surprised with those. I've only got a couple left, and I'm more than happy to continue. And yes, absolutely. I'm very sorry about the computer problem.
Oh, no worries.
Thank God for mobile phones so that I could still do this.
Yes, and I just wanted to I think maybe get this question's for Gavin, but I just want to make sure we can stay on because I'm looking at the ticking clock counting down. So if maybe you could confirm, and then I'll just ask my next question while we're figuring that out.
Okay.
What are the immigration deportation relief options available now, and how will that differ in the near future?
So I took this to mean cases in court, and I'm reading it now, and I realize that you could read it either affirmatively or in court. So when I say affirmatively, it means that somebody qualifies for something and applies for it. Like they get married to a US citizen and they apply for permanent residency here in the US. At that point, they're not facing deportation because either nobody knows they're in the US or they're in another status. They've overstayed a visa, something like that. So talking about what's available in court, and I'll talk more about asylum, withholding of removal, and CAT. Those have to do with individuals who are facing persecution or torture. Adjustment of status is applying to become a lawful permanent resident through a relative, and it has to be a U.S. citizen parent, LPR or citizen spouse, or a U.S. citizen child petitioning for parents. That can happen both affirmatively, or if you end up in court, for example, your application was denied initially, you would end up in front of an immigration judge, and then you apply in front of the immigration judge. So you don't want to be in immigration court, but if you end up there, you'd have a second chance. The marriage fraud amendments required that 2 years after married couples get conditional residence, that they apply to remove those conditions based on their ongoing good faith marriage. That can be renewed in court if it's denied by USCIS. You can apply for TPS or late filed TPS. So let's say you missed the initial deadline, but you end up in immigration court facing deportation. You can apply for late filed TPS there. There's something called cancellation of removal for non-lawful permanent residents. If they've resided in the US for 10 years, have good moral character, and a qualifying relative would suffer extreme and exceptionally unusual hardship. It's a very, very high level of hardship and difficult to prove, but that is something for non-LPRs. And there is also cancellation of removal for lawful permanent residents who've committed certain crimes or offenses that made them deportable, and they can apply for it exactly once and never again. So if they are in that situation, they have a very good chance. There is also non-court relief that you can apply for tangentially and request continuances in court, like U visas for crime victims, victims of certain crimes, T visas for victims of severe forms of human trafficking, or special immigrant juvenile status for kids who've been abused, abandoned, or neglected. So that's the summary. That's a very quick summary of what's available. Obviously, the law is much more complicated, and I'm not giving legal advice.
Thank you.
Sure.
I think you touched a little bit on this, but I'll just ask the question in case you want to expand. Tell us about the asylum process. Who qualifies for that under the law? How does the process work? And what kind of documentation does USCIS look for? What kinds of relief do you foresee changing in the next few months?
Okay. Yes, I'd be happy to go over this. So asylum, you can apply either affirmatively if you're not facing deportation. So let's say you're an F1 student, but you come from a country where you fear persecution. You can apply affirmatively, and you would go through an interview process, or you can apply in front of a judge. Affirmatively, right now, the waits are about 10 years, and in the court dates are being set out to 2030 right now. Depending on which location you're in, there are certain courts, like Wisconsin is not as backed up as Seattle or Los Angeles or San Francisco. There is the 1-year filing deadline that's very important for people who came here without status and need to apply. Asylum is, I'm afraid we're going to be cut off, but I'm going to keep talking. Asylum is for people who fear persecution or have suffered past persecution based on race, religion, national origin, political opinion, which can encompass like labor activity, not just electoral politics, but the whole realm of political opinion, or membership in a particular social group. And social groups can be families. It can be someone who is, I love to chat. It can be somebody who's LGBTQ+. It's an immutable characteristic that the person cannot change, or they may be regarded by others, may be imputed to be LGBTQ, or maybe imputed to be tied to a gang or something like that. Gang cases are very hard to win. They might be believed to be a witness against a criminal organization. There's certain protections for witnesses, that kind of thing. Withholding of removal is granted if somebody misses the 1 year, or is considered if you've missed the 1 year filing deadline, so you're not eligible for asylum, or if you've committed a crime that means you're not eligible for asylum, but you still have a more likely than not chance of being persecuted if you were sent back to your country. What happens is you're ordered deported, but they won't deport you until there's no longer a risk of persecution. ICE, as a practical matter, will ask you to identify 3 countries and see if they will take you. I typically choose like Western countries that really don't have a need for extra people and will say no. But they really want people who get withholding or CAT to be looking for other countries that will take them. It's a strategy of theirs that I think is weird. The Convention Against Torture is an international convention that the US has signed on to, and it says that we will not deport people if they will be tortured in their home country by their government, or if the government will turn a blind eye to the torture. So that has a much higher level of proof, and it's specific to torture. But for example, there are countries like Haiti where if you are deported, they think bad things about you. They will put you in prison, and their prisons are known for torture, both conditions that are so bad they amount to torture and actual affirmative acts of torture. So CAT is something that's available if you haven't proved that you'll be persecuted, but that you believe you will be tortured. It doesn't get you permanent status. Neither withholding nor CAT will get you a path to lawful permanent residence, but they will allow you to stay and have work authorization while you're at risk of being either persecuted or tortured according to the form of relief. What kinds of changes do I expect to see? Well, the rate of approvals for asylum has gone down. I've been practicing immigration law exclusively for 23 years. The rate of approval has gone down. There's a lot of negative press about asylum seekers, both here and in Europe. I personally think a lot of that is misinformed. I'm concerned that the approval rate will go down. I'm concerned that the administration will implement other policies that require immigration judges to deny more cases. There is case law. So our law in the US is made up of both laws, policies, regulations, and case law from other cases. What may happen is that favorable precedent cases from the Board of Immigration Appeals will be withdrawn and replaced with new decisions that are negative or more harmful to immigrants. That did happen from 2017 to 2021, so I feel pretty confident about that. I think the tone will change in terms of discretion, and I do think there will be more denials. However, the courts are so backed up with a 3.4 million case backlog that if you get a court date in 2028, your final hearing will probably be into the next presidency, whoever that is. We don't know that far out. So there's lots of different considerations. It's a pretty complicated area, but I do foresee it being harder to get. Also, the current administration put in place a circumventing lawful pathways policy that says that if you entered the US other than at a port of entry where they're metering who can come in by using a CBP One app, if you try to sneak in other than through those official points, you are not eligible for asylum. And they're finding that when they get to their court dates within the interior of the US and the judge makes a decision, there are very narrow exceptions. That's already in play. And decisions are being made using the CLP to exclude people from applying for asylum. I think that may be violating our participation in the Refugee Convention, where we agree not to send people back to countries where they face persecution, but that is the current policy, and I don't expect that would be rescinded.
Thank you so much. So just
Of course.
update, I think that the Zoom will not kick us out. And so
Oh,
I think we'll just kind of ask you the remaining questions, and if folks have to go, we'll be sending the recording and other resources. Just
That sounds
because-
great.
Thank you. It's just rare that we have the opportunity to get this time with a lawyer who knows these issues. So thank you so much. Yeah, we don't have very many questions left. So can you talk about what is VAWA and who qualifies?
Okay, now I know that the representatives from IFCJ talked somewhat about this, and I was at a neighbor's office trying to print out my presentation because my computer doesn't work. So I missed what they said. I apologize if I duplicate anything. VAWA is, the law is called the Violence Against Women Act, but it also applies to immigrants who are men, male, or non-binary. So even though the law says violence against women, and the majority of domestic violence victims are still women globally and in the US, immigrants are about 30% more likely to be victims of domestic violence. And that was part of the reason for the genesis of this law. We fought long and very hard for this law because, and I know some people discussed, there are a lot of different ways that US citizen or lawful permanent resident partners may use immigration status, economics, coercive control measures, the children, pets, isolation, or physical violence in order to abuse immigrants who are married to them. So the key with VAWA is that the immigrant must be married to either, okay, there's 3 categories of people who qualify. If you're married to a lawful permanent resident or a US citizen spouse, if you're not married, you might qualify for a U visa if you called the police and were the victim of a qualifying crime. If you're the lawful permanent resident parent who abused a child under 21, that child can apply. So LPR or US citizen parent. Or if you're a parent who was abused by a lawful permanent resident or US citizen child when the child was under 18, you can apply. There's actually been a lot of abuse in that category, so we have some real concerns about that. But people are eligible if they have a case. Again, this doesn't apply if you're on an H-1B, you're the spouse of an H-1B visa holder, and you're abused. Your best option is to call the police and start establishing a paper trail that way. And certainly, it's not perfect, but police are trained at least somewhat to deal with domestic violence, and domestic violence can escalate over time. So getting help, developing a safety plan, and getting hopefully out of the situation, if that's what works for the survivor, are all very important measures in addition to applying for immigration status. But if they are facing a pattern of coercive control, which is considered domestic violence in the state of Washington, or they've experienced physical violence, they should call the police and make a report and get help, and then contact a shelter or advocacy organization that can give them an advocate and help them start understanding their rights, help them with shelter if they need it, and other resources.
Great, thank you so much.
Sure.
This is one of the questions, sorry, we're entering into the bonus question land. I don't think you had it in advance, but this was one tagged specifically for you from previous speakers. Some colleges are advising students from mixed citizenship status families, i.e. students who have citizenship or DACA, but parents are undocumented, to avoid applying for federal application for federal student aid if it means listing their parents' addresses and information on the form. This questioner would like to know if this is generally being recommended now, and if so, if it also applies to other federally funded programs like work study.
Wow. Okay, I have not heard of this one. And I have not read any articles about this one. When somebody, let's just use the example, if somebody's applying for lawful permanent residence, so a US citizen, grown-up child with undocumented parents applies for permanent residence based on, well, maybe they're undocumented, but they're applying for permanent residence through a US citizen spouse. They still have to list their parents and their children. So we routinely list undocumented family members, and big data keeps getting more and more advanced, which I suppose is a concern. But in general, we have not seen any apprehension of those family members when somebody is applying for status, because there's just so many people applying for status. They typically would go after bigger fish. Like perhaps if they're noticing a pattern that a local employer is employing a lot of these parents, they may go after that employer, but they typically don't go after the people who are mentioned. And for example, immigrants they pay taxes and they file tax returns, and they need to file tax returns both to get their refunds and also to prove that they have good moral character. And they're listing dependents. They can get what's called an individual tax identification number and file taxes. They may be undocumented themselves or listing undocumented dependents. And IRS records are supposed to be kept completely separate. So that should never be used. There are other places where people are applying for something and they're listing undocumented family members, and we haven't seen that typically used as a source for apprehensions. There was a period, I think during Jay Inslee's second term, when our State Department of Licensing was handing over information about who did not have Social Security numbers to ICE and CBP, and that was stopped. But even with that inappropriate release of information, I'm not aware of specific apprehensions as a result of that. It was just too much information. And there's actually been a lot of reports with this big data with Palantir and with Pegasus, the really big surveillance and data aggregation systems. They are surveilling US citizens. So nobody is exempt from this big data. And even though they're specifically not allowed to, ICE and CBP have access to all kinds of data about US citizens, and they use it. So they're also doing that with immigrants. I think that the students would be better served applying for FAFSA because it's the only way they can get aid and continue their education. I am not aware of any specific release from the Department of Education for so long as it continues to exist. From FAFSA to ICE, for example. But I think that information could probably be found many other ways, not just from the FAFSA. And I would rather see the young people continuing their education and making sure that the family members are getting appropriate immigration representation in case something happens, because being proactive is so important. It's very hard when you suddenly face a notice to appear in immigration court and you have no information about the client's background. So I would say, know that this information is available a lot of different ways, including within Washington State, since we're one of the states, and I'm proud to say we have been for a long time, that will give driver licenses to undocumented immigrants. That data is out there.
Thank you.
Sure. That's a tough one.
We arrived at our next question.
Okay.
Thank you, everyone. So the last question was actually put in the chat earlier. Can you recommend a few credible news sources that specialize in immigrant news and immigrant law updates?
Oh boy. BuzzFeed used to have, that sounds ironic, I know, because they'll recommend 30 products you need right now. They used to have some really good immigration reporters, but they have moved to other places. So I tend to look at mainstream media. And when I hear a report, I will go first to Washington Post and New York Times, Seattle Times if it's regional. The AP and Reuters are good. I haven't used Al Jazeera as much for immigration reporting, but they do good long form journalism. Certainly NPR. And any of them can make mistakes, but if there's a big development, it's going to be covered by more than one, and people may have to investigate further to find out the details. If it's a policy announcement, it should be released either on the USCIS website or on the Executive Office for Immigration Review, EOIR, which is the immigration court. There should be something there. One thing that's tricky is that whatever the next administration comes up with, the immigrant advocates, me and my colleagues, we will be suing against bad policies. And unlike a class action, say, I just got $11 from Verizon for something. It was a class action lawsuit. When there are class action lawsuits in immigration land, they don't notify the individual immigrants who are affected. They have to find out either through posts on websites or through a lawyer. This bothers me on a personal level. It's my axe to grind. But that's something that requires having a lawyer who knows the law well. But there will be litigation, and if there are lawsuits, and if there are stays or restraining orders, permanent restraining orders, or temporary injunctions against new policies, those will be publicized. And I remember in the early days of Facebook and, sensational news, if it makes you feel really emotional, you probably want to check a couple sources to see if it's true. And if it shows up in one you've never heard of, or it's like Dave's News, no offense to Dave, but it's probably not credible. If it's real, it's going to show up in multiple sources. So, I think nowadays there's somebody who does a kind of a temperature spectrum graph that shows where the news organizations tilt liberal or conservative. But if you're looking at those and you're hearing reports on more than a couple, then it's probably real, and you may need to investigate further to find out what the actual law is. But at least you'll know that something's happened.
Thank you so much, Diana. Thank you, for taking all this time with us.
Oh, it's my pleasure. I'm happy. Is there another question? That was
No,
a tough one.
I think we're at the end. But I think, we will send out this recording to everyone who registered. We will send out any resources that were mentioned. And if, any of our speakers want to send us resources, we'll be happy to send them out. Thank you so much, everyone, for coming. And thank you, Diana, again, and all our other speakers. And yes, we're we're gonna stick together in 2025 and work together to, well, fight off anything that's coming that's negative, and hopefully band together to organize great things.
Fight the fear, think critically, and talk to a real immigration lawyer who does it full time. You don't want to go see a dabbler. You want to see somebody who's dedicated to it. I'm very passionate about it. I hope that shows through. And I've been honored to serve with these other speakers, and honored that you would have me to come talk about this. Thank you so much for this opportunity. I really appreciate it.
Thank you. It really comes
my
through.
pleasure. Oh, thank
Yes.
you.
Thank you, Diana.
It was my pleasure. Thank you.
Thank you. Bye, everyone.
Bye.
Bye. Thank you again.